Anderson Township Board of Zoning Appeals is hereby called to order. The board was established pursuant to Section 519.13 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Will the secretary please call the roll?
Mr. Nye.
Here.
Mr. Sion.
Here.
Mr. Haber.
Here.
Mr. Halpin.
Present.
Mr. Shekels.
Here. Thank you for coming to this meeting of the Anderson Township Board of Zoning Appeals. Please be aware that this meeting is audio and videotaped and may be carried live on television. First, I'll outline our procedures. A summary of the appeal is presented by the staff. Then the appellant will present its case. The board members may then ask questions of the appellant. After that, all persons supporting the appeal will be permitted to testify one at a time after being recognized by the chairman. When these persons supporting the appeal are finished, those opposed to the appeal will then be permitted to testify and or ask questions of the board after being recognized by the chairman. All persons wishing to testify, whether for or against an appeal, may only do so after being sworn in. When testifying, each person must come forward to the podium and after being recognized, speak into the microphone and state their name, address, and any affiliation to the case. All persons testifying will be limited to 4 minutes unless a board member requests additional time. All testimony is given to the board only. No comments or questions are redirected to the appellant or anyone else in the audience. The board will only hear new, non-repetitive evidence or questions. Should someone wish to show support of previous testimony, they may do so by following the testimony procedures and stating their support of the previous testimony. Now, all persons who may give testimony this evening, please stand, raise your right hand, and swear and affirm. I just want to make sure who's standing and who's not standing. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Are there any changes to tonight's agenda?
Yes, as the last item, we need to elect officials.
Oh, okay. Well,
Yeah.
we can do that after.
Yes.
Very last, everybody's
Yes.
done. Okay, all right. Okay. Okay, if there are no further changes or objections from the board, the minutes are approved as amended by unanimous consent. Are there any changes to the minutes from the previous meeting?
No.
Hearing none, if there are no objections to the board, the minutes are approved by unanimous consent. As a matter before starting on our regular meeting, I talked to Paul this week regarding one of the cases and asked for clarification. And Gary is here tonight to give a clarification on that.
Do you want to open the first case and then?
No, I'm
Okay.
good with you
Okay.
going now.
Yeah, so the first case is going to be an appeal from an interpretation of the zoning staff. So under section 2.12D 1 of the zoning resolution, the Board of Zoning Appeals has the following powers. And the first one is to hear and decide appeals where it is alleged there is error in any order, requirement, decision, or determination made by an administrative official in the enforcement of this resolution. So unlike a variance where you're looking at whether there's a request to change the way the zoning resolution is written, this is an appeal from the interpretation of the staff about how the zoning resolution can be enforced.
Okay.
Okay.
So just to clarify, so what we are hearing in this first case is whether the staff did the proper paperwork and properly handled that. We're not hearing the case itself, we're handling the staff's actions, correct?
Yeah, sort of, yeah. I mean, you have, in a variance, you're looking at a specific piece of property and whether or not the zoning resolution requirement should be altered for that particular property. You're looking at a provision in the zoning resolution determining whether staff interpreted that or those provisions correctly. So, unlike a variance that applies to a particular piece of property, this kind of decision could then control the staff's interpretation of the same sections later on. So you're not looking as much at the property itself, how it's situated, why they're, requesting what they're requesting, but you're looking at, did staff handle the interpretation of the provisions that they've applied correctly or not?
And then, after we make that decision tonight, then there will be a separate appeal at a later time
No,
for
I
the
mean,
rest of it?
if you determine that the staff made an error in its decision, then you basically put the BZA's interpretation of how the staff should have, you should put the BZA's decision about how the staff should have interpreted that particular section or sections.
All right, I just want to make sure everybody's on the same page.
And I'll be here throughout the hearing, so if you need
Any
any questions.
questions from the board?
Question only a lawyer would ask. What's our standard of review? De novo?
It's not clear. I think it's de novo.
I think so too.
I think it's, obviously you make a decision about, how it's being determined. It's just like a question of law in front of a court of appeals. So I think it's de novo. I haven't seen anything that would alter my opinion on that. I think it's de novo.
Should we explain that to the non-lawyer?
Yeah, de novo is basically.
would.
Many times when a court hears a case on like say a 2506 appeal, say somebody applies for and is denied a variance, they file a 2506 appeal. That question then goes to the Court of Common Pleas for review. In that kind of situation, the court has to give some deference, or they're supposed to, they don't always do, but they're supposed to give some deference to the BZA's decision-making processes, because you guys are the local government officials or the officials that have been appointed by the elected officials to do this particular job that's provided by the Ohio Revised Code. So the courts are supposed to give you some deference as far as your familiarity with the code, your expertise, so to speak, at least your experience in dealing with your particular zoning resolution.
Okay. When we go to executive session, do I have to do anything differently so that you're
No.
part of the executive session? Or
No.
you can participate in executive
Us
session?
attorneys always have the ability to
I
go.
know. I just want to clarify so everybody's
Yeah.
on the same page.
No, I
again.
appreciate that. But so the difference is when a court of appeals looks at a question of law as opposed to reviewing how, for example, if they follow the procedures in making a decision on a variance, when you're determining the interpretation of law, what you'll be doing here is de novo. In other words, you don't have to look at the BZA's decision with any particular deference. You're now the decision makers. How would you interpret this provision based on your knowledge and experience in dealing with the Anderson Township zoning resolution?
Jeff? Yes.
I would say we come at it with a clean slate. We don't
Right.
necessarily presume that the staff's interpretation is correct.
Right.
We look at it, we make our best determination of what it means,
Correct.
and go from there.
Okay. Any other questions for staff regarding
let
this
me-
before we go into the
Yeah.
report?
Let me just kind of clarify a little bit, because de novo, I mean, typically the burden would be on the applicant to prove his or her side of the case. When it's de novo, it's basically being presented to you without, I mean, the property owner has to show why they think the staff was in error, but you don't have the same, like I said, kind of the deference. It's kind of, the clean slate where, there's not as heavy a burden of proof. It's just they have to present the evidence showing what happened, why they think the interpretation is wrong, and then you guys decide who's right.
Any other questions from the board before we proceed? Okay. Will the staff read case 1-2023 BZA?
Case 1, 2023 BZA, applicant Michael and Carol Voorhees, property owners of 7999 Spicewood Lane, zoned B residence. Request, it's an appeal of a zoning violation letter dated 11/15/2022 regarding a 6-foot-high privacy fence installed without a zoning certificate in the front yard, where 6-foot-high privacy fences are only permitted in the rear yard. Site history, April 2008, the current property owners purchased the property. July 19th, 2016, a zoning permit was issued for a fence, 4-foot-high decorative aluminum, 75% open, to be located in the front and side yard areas. Case history, November 15th, 2022, the township received a complaint indicating a possible zoning violation of a 6-foot tall privacy fence located in the front yard of 7999 Spicewood Lane. November 16, 2022, staff confirmed the violation while performing an inspection of the property and sent a letter of violation to the property owners. November 28, 2022, staff received an email response from Mr. Voorhees. In this email, Mr. Voorhees stated that he disagreed with the Anderson Township zoning resolution, Article 2.1 and 5.2A9. Mr. Voorhees asked staff to rescind the letter of violation. November 29, 2022, staff responded to Mr. Voorhees' email stating that according to the Anderson Township zoning resolution, a zoning certificate is required for the fence and that the unpermitted fence had been constructed. Need to catch my breath, sorry. In the front yard area, instructions were provided for how to obtain a permit and how to apply for the Board of Zoning Appeals. December 5th, 2022, staff received Mr. Voorhees' application for an appeal of staff's interpretation of the Anderson Township zoning resolution. This is a property map. As you can see, the lot is a corner lot. It has frontage on both Spicewood and Huntcrest. Here's an aerial map. You can see that it's a little more wooded or more foliage towards the south. Topography, it's slightly more flat up top, but gets steeper the more south you go. And this red line is the allowable location of the 6-foot fence. This is what is considered the rear yard according to the Anderson Township zoning resolution. And then these dots are the approximate current location of the 6-foot high privacy fence. We believe it partially goes into the right-of-way. These are photos of the fence. This is a view on the Huntcrest side. The property in question is here, and that's the fence. In this view, you're looking at the fence kind of through the foliage, and the fence is behind here. This is the side of the house that faces Huntcrest. This is all considered front yard area because it has frontage on that street. This is the side of the house that faces Spicewood and has that permitted fence. Findings. According to the Anderson Township zoning resolution, a fence is considered a structure. Per the definition below, structures are required to receive a zoning certificate. The fence installed without a permit is currently located in the front yard area of the property. The definition of yard and front yard are found below. The property is located on a corner lot of Spicewood Lane and Huntcrest Drive. Article 5.2A9 states that basically that 6-foot high privacy fences are only permitted in the rear yard, and 4-foot high 75% open fences are permitted in the front and side yards. And here's a diagram showing front setbacks. And this is the standard to be considered.
Okay. Are there any questions from the board?
Can you just go to the aerial again one more time? The one with the dots is actually what I wanted to see again. Yeah, okay, that's what thank you.
And I want to make a clarification on this diagram in particular. This was produced by staff. The dots are just approximate locations based on our site visit, the aerials. We never have actually received a site plan from the applicant.
Okay, thanks.
And actually, if you could, I'm just trying to translate this to the diagram in Article 5.2, which I forget which slide it was, but Yeah, so if we rotated this 90 degrees clockwise, which I know you can't do, and then flipped it across what it would then be its vertical axis, we'd have the house that we're looking at, right? So the front setback would be at the top and down the side, and the fence would be on the right. That made sense to me. You don't have to answer that. I don't have any other questions.
Any other questions from the board for the staff? Okay. Will the appellate or the appellant's representative please come to the podium, speak into the microphone, state your name, address, any affiliation, and present your appeal.
Thank you. Good evening. Mike Voorhees, owner of the property in question. Could you put the dots back up? Because I think that's key. I can be very brief and to the point on what I need to say. Yesterday, I did have an opportunity to talk to Gary Powell, and we discussed the case and his thoughts on it. What I think is an error here is, well, first the dots. If you look at the picture behind you, it starts in the street on the dots. That's not where the fence is. The fence is off the street, off the sidewalk, and I think in the allowable area. I disagree with the interpretation of a rear, front and rear. I think the fence is clearly in the rear, and I guess what the staff is saying is that if the fence started at that red line over, it would be no issue at all. Well, that can't happen because there's a creek and there's a concrete block that would prevent that. Excuse me. So the fence is where it has to be and needs to be, and so I ask that the board find that there's no violation. It's a proper place, and also in talking to Gary Powell, Gary suggested that a variance might be appropriate. First off, I don't think there's a violation, so I don't think I need a variance, but in the event that you would find that there's an issue here, I would ask leave to file for a variance.
Anything else you'd like to add?
No, I think that's right to the point.
Jeff, you have any questions?
Yeah, Mr. Voorhees. Mr. Voorhees, I'm looking at this sketch, and I think going down the property line, kind of below the dotted line there, there's like a blue property line. Do you see what I'm indicating there?
Are you up on this here?
I'm looking at the same thing you're looking at.
Okay,
You see
yeah.
where it says P201 down there at the corner? There's a blue line going down from there, right?
Okay.
And there's a gray line to the right of it. Is that sidewalk?
There's a sidewalk. There's no sidewalk on our property.
I'm not asking about your property. I'm asking about the next property.
Yes.
I'm just trying to figure out.
Right.
So,
If
so the
you look at
dots-
the pictures, you can see there's a sidewalk.
That's what I thought. So
Right.
the dots don't show it going into the road. They show it coming up just past the edge of the sidewalk. Is that right?
And that's incorrect.
It doesn't come past the
It does
sidewalk?
not. If you look at the pictures, there's photos that the staff showed right there.
So it does come past the sidewalk.
Well, I think that's a bad angle. Was there another one? Right there. If you
So-
look at that one.
Is your view that it comes to the edge of the sidewalk or close to the sidewalk, or can you
It's
describe?
close to the sidewalk, yeah.
And so your contention is that because your address is on Spice Wood,
Yes.
that's the front of your house. This is therefore the back of the house.
It is the rear, yeah. I don't think there's any question. I mean, common sense wise, I mean, you could look at these definitions and they do get convoluted. You know, I do know how to read statutes and resolutions and things. And this, I don't think there's a clarity here in the resolution, but I think it's, if you look at it at common sense, that's the rear yard.
Mr. Chairman, if I can point out
Yes, feel free, Gary.
the zoning code does, in the definition of a rear yard, or yard, comma, rear, talks about corner lots, and it gives two options for the rear yard. So on corner lots, the rear yard is generally considered to be parallel to the street upon which the lot has its least dimension. However, the rear yard may be approved parallel to the street upon which the lot has its greatest dimension if the minimum distance from the structure to the rear property line complies with the minimum rear yard setback required in the zoning district. So when you look at the map, the part
Excuse me, can you pull that
on
map back up?
with the red, that is, under the way the code is, that is clearly the backyard, the area encompassed within the red lines. That's the rear yard of the property under
Okay.
that definition.
Okay, thanks. Paul, do you have any questions?
Not at the moment.
Steve?
Nothing at the moment.
John? No. I don't have either at this time. If there are more questions from the board, thank you. Okay. Is there anyone present who would like to speak in support of the appeal? In support of the appeal? Hearing none, is there anyone present who would like to speak against it? Please come to the podium, identify yourself, and state your affiliation to the case.
My name is Teresa Boeing, and I am the owner of the property at 1557 Huntcrest Drive on the other side of that fence.
All right.
In November of 2022, a 6-foot-high privacy fence was installed near the common property boundary of 7999 Spicewood Lane and my property at 1557 Huntcrest Drive by the owners of 7999 Spicewood Lane, Michael and Carol Voorhees. The fence was built near what I understand is the rear and front yards of 7999 Spicewood Lane, a corner lot, and possibly on my property in my side and front yards, extending into the Huntcrest Drive public right-of-way. The property is zoned B residence. The fence was installed without the property owners of 7999 Spicewood Lane obtaining a zoning certificate. The fence is a violation of Article 2.1, requiring a zoning certificate to build a structure that complies with the provisions of the resolution. The fence is in violation of 5.2A9, limiting the size of a fence built in a side or front yard to not be more than 4 feet high and 75% open. According to Mr. Chris Cavalario of the Anderson Township zoning, the fence was placed on a right-of-way. Mr. and Mrs. Voorhees are the owners of the property of 7999 Spicewood Lane, but they do not occupy the property, assuming they rent or lease the property. Mr. Voorhees is a member of the legal profession and acts as an attorney for the firm of Voorhees and Levy, LLC. Another fence was installed several years ago around another portion of their property at 7999 Spicewood Lane. A zoning permit was obtained for that fence by the owners of the property. Therefore, Mr. Voorhees, the Voorhees are aware that permits are required for installing a fence. Conclusion being, the Voorhees elected to violate the zoning regulations in this case and assume that no one would report the violation. This fence is an eyesore and decreases the value of my property. I request that the code be adhered to and the fence removed immediately. And I would like to call Tim Hirschner as a consultant.
Okay, well, he can come after you. Let's finish our conversation with you and the board. You have anything else to present to us?
Yep.
Any questions from the board?
You mentioned another fence. Am I right to think that it's between 7999 and 7791 there?
No, the other fence I'm referring to goes all around the portion of their yard that.
Are you
Right
talking
there,
about
that
that
one.
fence?
Yes, he obtained a permit for that one.
Okay,
Sorry.
thanks.
Thank you.
Any other questions from the board? Anything else to add?
Nope,
Okay, thank you.
thank you.
Is there anyone else who would like to speak in opposition? Please come to the podium, identify yourself, and state your affiliation.
Thank you. My name is Tim Hirschner. I'm a land planner. I've been in the profession for over 40 years in Cincinnati and representing the property owner to the south of the subject fence. The picture that's in front of you right now, I would say is the best angle to look at how the fence does encroach into the public right-of-way. You're looking straight down the sidewalk line the public right-of-way boundary is on the left side of that sidewalk. And so if you project that line straight towards the fence, it runs into the fence. So clearly, in my understanding, that fence is partially into the public right-of-way. Staff is correct in asserting that. And my concern after looking at the fence in person, as well as reviewing Cage's property maps, I'm a little concerned that the fence, if you look at it from the other angle, there is a bend to it where the property line, that's good. The property line is a straight line. This fence bends off to the left and then comes back to the right as you go down that straight property line. I could not find any markings that there are any stakes to prove where the property line is, but that remains a question in my mind, whether or not as that bends outward into my client's property, if there is any encroachment there. In any event, the staff is correct in that the fence is wholly within the front yard portion of the subject property. I'm not surprised. Many people are confused about how the rear of their house could have a front yard. But when you're on a corner lot, you have 2 front yards, 1 rear yard, and 1 side yard. And the way that other picture with showing where the red line is of the rear property, it clearly, there's only room to the west of the house that allows for a side yard setback to occur. So the rear yard has to be to the south of the house, southward to the property boundary. And then when you draw the line from the eastern face of the house, straight from the back corner on the east side, due south to the rear property line, all that within the red line, that is the rear yard. Everything to the east of that red line on the eastern side of the lot is a front yard. So I concur with the staff's report, and really, I think it's a very simple case that this is clearly in violation of the zoning code.
Thank you. Are there any questions from the staff?
Is there any fencing in that backyard?
There, from what I could see, there's no fencing, and with the comment about this is the only place a fence could be placed, I handle a lot of zoning plan reviews throughout the county, and typically what I've seen is because of the grade, the fence typically, if you want a privacy fence, it gets placed in the rear yard within those red lines at a point that's going to actually offer some privacy. With the way the grade of that lot falls off, you're not creating any privacy except for right in the creek itself at that point. So typically privacy fences are erected halfway up the rear yard or somewhere closer to where somebody can enjoy privacy on the back side of their house.
Okay. Thank you. Are there any questions from the staff? Jeff? Thank you. Is there anyone else who'd like to speak in opposition? Please come to the podium, identify yourself and your affiliation to the case.
My name is Christina Willis. I live at 1549 Huntcrest, so I am the second property below the graph up here. I'm a neighbor and I'm also an architect.
Could you speak just a little louder?
Sure.
I'm sorry, what was that?
I'm a neighbor
Yes,
to the
and?
residents and an architect.
Thank you.
So very familiar with zoning codes, interpretations of them, the setbacks, so I'm in agreement with all of the other things that have been brought forth. As a neighbor that drives Huntcrest frequently and walks the sidewalk, this fence is actually a safety hazard. You have to walk up to it and kind of look around it. We have a lot of deer and other animals that cross through that area. So as you drive down the road or you're walking, something can pop out. You know, it's very very disconcerting. The other item that I wanted to bring up is there's a house catty-cornered at the dogleg of Huntcrest that is a very similar situation. It's a corner lot, and Kevin and Jill put in a fence that abides by the zoning resolution, and it clearly follows the diagram that's up here where the two front yards are respected and the fence is only in their private backyard area. So to make an exception for this one, when it's not only a visual concern and a hardship for Terry to look at on a daily basis, I find that that would be inappropriate.
Thank you. Are there any questions from the board? Thank you. Is there anyone else who'd like to speak in opposition? Mr. Voorhees, do you have anything you would like to add at this time?
Well, I do. I mean, the dots are clearly wrong. So without going out there to measure, things, I don't know how you're going to say what's what tonight. But I think it's on the rear. It's on our property. It was surveyed years ago. There are stakes there. Someone did tamper with the one marker, but there's another marker out there. So there's no question. It's not even on the line. It's in the setback. It's well within our property, and I don't think it's a violation at all. So as far as the other issues, we're not getting into the purpose or the other issues. That's for a variance hearing. This is just a matter of interpretation.
Any questions from the board?
I do have a question. Why?
Well, I think in my appeal I did state the purpose, and that goes to the variance
I'd just
issues.
like you to state why. It doesn't look to me like there's a fence in the backyard, other
Okay,
than
so-
this piece that you
So
just put
two
in.
issues, okay, and if you want to get into it, it's an Airbnb.
What is?
The residence that's right there. Okay.
7999?
No, no, that's our property.
Do you live in that property?
My daughter does. She always has.
Okay.
So
So you're
the
saying the house below it?
yes, where the
There.
fence is, it's an Airbnb. And I've been in front of this board before speaking against Airbnbs when I residents. It's a real nuisance. And I'm telling you, I live on Collinsdale, and they had the first one. It's a nuisance. It changes the, I know this isn't for your board, it's for the Board of Trustees as far as, that's where you decided, actually 3-2 when I was here last time. And I know, talking to Gary Powell, that this may be grandfathered into it, but there's a creek there. And in the Airbnb ad, it says the property includes with creek. So if you're renting this place, you're going to think, oh, that's that. And we have a concern about people going down into the creek, so the liability attached to that. The other part is neighbor issues. And that's, they have continually for years come across, cut our shrubs there where we said, don't do that, we don't want that. They continue to throw trash into the creek, and it's an overall harassment type thing. So those are the purposes, and I did get into that. And if I do have to file for variance, I can detail that even more.
Thank you.
One issue that did come up about the zoning certificate, I told Gary that I just relied on the fence company, and he didn't think one was required. So that's why I didn't apply.
Let's be clear, the fence company representative did not.
Yes. Right. So I just relied on that when we were installing it. If that resolves the issue, I ask for leave to file for that too.
Any other questions from the board?
Can you tell me how far it is from the south side of the house to the south property line, about? It looks to me like it's maybe 70 feet or something.
I don't know.
I mean, it's dozens of feet, right?
Oh, yeah.
And from the north side of the house to the north property line, it's somewhat less, but it's, dozens of feet again. It's 20 feet, 30 feet, whatever it is, right? Okay, from the east side of the house to the east property line, about how far is that?
I don't know.
You don't know. From the west side of the house to the west property line, how far is that?
You're asking for feet, and I don't know. I mean, that's a fair depiction of,
I mean, it looks like it's 8 feet or something,
Okay.
right? 10 feet, 12 feet, something like that, 6 feet. Is that, on the order of right?
okay, okay,
I-
yeah.
Here's why I'm asking.
Yeah.
The code says that to be a rear yard, you've got to have 35 feet. Okay?
Mhm.
So I'm looking at the west side of the house.
Mm-hmm.
Okay? That's not 35 feet.
Right.
Okay. So I got to put a rear yard somewhere else. That's what the code seems to suggest to me.
The rear yard is the line by the creek.
Yeah. So what the code says is that you presume the rear yard is opposite the short frontage. So the short frontage on Spicewood. I'm just trying to talk through this to
Sure,
figure out where
sure.
I'm going. The short frontage is on Spicewood, right? So the rear yard is going to be opposite that, right?
So looking at that, the rear is longer in dimension than the front yard. Is that what you're saying?
Well, I guess the problem I have is that you've definitely got a street on the right side of the house. So you got to have a street you got to have a front yard on that side of the house. That's the way the resolution looks to me. So where's the front yard on the east side of the house?
I don't agree with that interpretation. I mean, I think, even if you look at the corner lot illustrations in your resolutions, it still has a rear yard setback. So are we
yeah.
talking about that the fence is too close to the sidewalk? I mean, if it was over further, because what the staff report says, the red area is the allowable area. So I think what they're saying is, if the fence was over there, they wouldn't even issue this opinion.
I think that's right. If the fence were in the red area, it would be permitted.
Right.
I agree with that. The rear yard setback is the distance between the rear yard and any permitted structure, but that excludes fences. Fences can be within the rear yard setback. So I'm not concerned about the rear yard setback. I'm concerned about the front yard setback. Is that a front yard? If it is, a fence isn't permitted. And whether it encroaches into the right of way has nothing to do with whether it's a front yard. Whether it encroaches on the property next door has nothing to do with whether that's a front yard. I'm just looking at the code and saying, I got a street on the east side, means I got to have a front yard on the east side. And the front yard setback is, for B, is 35? It's 35. So it seems to me that you go from the right-of-way at Huntcrest, 35 feet to the west, anything in that area is a front yard under the code. Can you convince me otherwise?
I just don't agree that you can consider that a front yard. I mean, that's just, not trying to find here, just common sense wise, what's the rear line? I mean, it's the red area, and I think it's all the way there. So you're talking about setbacks.
A setback does not come into this. Or at least,
Okay.
in terms of the rear yard setback doesn't matter.
Well, you're saying that it's in the red area is the rear yard setback. That's what you're saying.
No. The rear yard setback has nothing to do with this. The question is that a front yard where the fence is? Right? That's a different question from setback, right? The question is, what's the yard? Once you figure out where the yards are, then you figure out what the setbacks are.
Yeah. I don't think your resolutions are clear. I don't, it's not, you know, that's not a front yard. The front yard is in the front. You know, let's, you know, just talk common sense. The front yard's in the front yard. The rear's in the rear. That's a side yard. Okay, then you throw in these definitions about corner lots. I don't think you find the answer here.
So, okay, I'm looking at the definition of front yard in the
Okay.
code.
Okay?
It says the minimum horizontal distance between the street line and the main building or any projection thereof. So the horizontal distance from the street line, any street line. So I'm looking at the street line of Huntcrest and the main building, which is the house, or any projection thereof, other than the projection of the usual steps or entranceway. So the front yard is the space between the street line and the closest point of the house to the street. So anything in that area, I think under the code is a front yard. And maybe that's not a common sense definition.
No.
And maybe if I was writing the code, that wouldn't be how I write it.
Is there a side yard definition in your resolutions?
There is. It's a yard between the main building and the sideline of the lot extending from the front yard to the rear yard.
Okay.
So in this situation, that'd be the west side of the house.
So you're,
That's your
so
side.
you're saying that's the only side yard?
Yeah. That's the way I read it.
I don't agree. I mean, it's just, I don't think it's.
I know you don't agree. Can you explain why?
Yeah, it's,
Can you explain why based on the text of the resolution?
and you're reading from, I don't have it in front of me.
I think it was in the staff report. Can you go to that page and
The lot
have
corner, is that what you're reading
I
from?
think that was what he submitted.
Oh, was that? Yeah, it was in your. Well, here. Okay, so there's the definition on the screen. Is definition of front. Is side in there also?
No, okay.
Does the next page have side and rear on it also?
Well, Jeff,
No. Well, I mean, stick with what we got for now. Paul, what are you gonna say?
well, it's, when you're on the corner lot, it's whichever side is closer is the front yard, is the way I would read that. But Gary, you had a clarification you wanted to get through?
I was just going to say, you know, the code provides definitions that, you know, I think the last one was, you know, in relation to the front yard. Clearly, well, the way the code is written, the way most zoning codes are written is that when you do have a corner lot, that's a different kind of situation. I mean, when you have a lot that's in the middle of a neighborhood, you have a front yard, you have two side yards, and you have a rear yard. But when you have two streets like that, it shows that you have two front yards, one side and one rear. And I think that's just an interpretation, whether or not that you guys agree with that interpretation the staff made. I think there's a lot of back and forth right now that probably isn't getting to the heart of it. I think, you know, it's up to you guys to decide, but, I mean, to me, it's, you know, a factual, or a legal question as opposed to a factual issue.
Thanks, Gary. Do you have any more to add, Mr. Morris?
Well, I just think, you know, the dots are wrong, so without going.
In what regard
Well, if you put
are
it.
the dots wrong?
Because if you look at it,
As an approximate location
yeah,
of where that fence is installed, approximate, I think Mr. Powell indicated that there was no survey done, so staff, in their ability to approximate the location, the dots are approximating the location of the fence. You're saying that's wrong.
well, the dots start in the street.
No, they don't.
No,
Well, yeah, I'm looking at, what is that?
That's the
That-
property line,
that-
not the street.
that
Okay.
line that crosses is the property line.
And
Which-
that
Oh,
below
that's,
is
see,
the sidewalk.
that's where
Yeah,
I was not understanding that.
no. That line where you're pointing now is the property line, not the street. And it's approximately a 12 and a half foot from that point to the curb, which is the right-of-way, okay? And the fact that they put a dot on one side or the other of the line is an inconsequential, in my opinion, item, and it can only be resolved with a licensed survey. Okay?
Can I,
Anything further to add from the
can I
staff?
ask him one more question?
Sure.
I'm sorry to beat a dead horse here.
No,
There's
you
another
can-
section of the code that I want to read to you. And here's what it says. This is 3.5B C. I'm sorry, no. 3.5 is, Article 3.5 is the B zone, which is where the house is. So 3.5 C 2 A little 1. Where lots have double frontage, the required front yard shall be provided on both streets. If that's the rule, how can I say that the east side is not a front yard?
No, you're pulling that out. I'm not, without going back and really studying it, I can't answer that question, so.
I understand.
So I get the sense that, you're thinking, okay, the staff report's correct, so if you are going to rule that way, I would ask for just a leave to file a variance.
And Mr. Chairman, there's no necessity for leave. You have the right to do that
Okay.
as property
I have
owner.
a right to do that?
Yeah.
Yep.
Can I file it under the same number?
I think that's a separate case. I mean, there's under the powers of the Board of Zoning Appeals, there's different powers. This appeal of the interpretation of staff is one type, and the second type is a variance. You have different other uses, but they're different cases.
Okay, thank you, Gary.
Okay. Anything further, Mr.
I
Voorhees?
think so.
Okay, thank you.
Okay.
Now, I'll give a quick opportunity for any who spoke in opposition. If you have any new information that you'd like to address in light of those conversations, and no one indicates they do, okay? We are going to go to executive session in just a minute here, and the board has the right to do executive session in a separate room, in a separate facility, and you would not have access to see or hear what we say. The board chooses not to do that. It has chosen not to do that on a regular basis. But when we go into executive session, we can talk to you, to our staff, and the board only. We can't communicate with you, and you can't communicate with us, okay? If we decide we want to communicate with you, or we sense that there's someone who has information that would be germane to the case, we'll come out of executive session here, okay? So, is there a motion to go into executive session?
Before we make a motion, did we want to clarify with the applicant if he plans on moving forward with his variance request rather than?
It's not germane to this case, okay?
Yeah.
Okay, is there a motion to go into?
So moved.
Second.
Second, will you read the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Before we go into discussion, I want to ask Gary a question, just clarification for our discussion. There's a lot of extraneous issues here that are not germane to what we're being asked to decide. We're being asked to decide, did the staff make the proper decision based on their observations of the property in question in a field view? Is that
Yeah,
correct,
it's-
Gary?
Yeah, I mean, it's whether they felt that the way the zoning resolution defines the different lots or yards or whatever, whether their application of those definitions was appropriate in this particular case.
And if we vote yes, that means we agree with the plaintiff and that the staff did not do it properly. And I want to get this clear. If we vote no, then we believe the staff acted properly in doing this.
Well, it depends
I mean, in
on-
my opinion, you
depends
could
on
do
the
it
motion.
based,
No,
Yeah.
I'm getting this all on the table
Yeah.
before we go into discussion.
could
So
do
we
it-
know which way we're voting, you know.
you could do it based on whichever way the motion goes. In other
Okay.
words, if somebody makes a motion to uphold the appeal and decide the staff misinterpreted the zoning resolution, that would be one motion, or the yes would be in favor of the applicant. On the other hand, if somebody made a motion to uphold the interpretation or affirm the interpretation of the applicant, then a yes vote would be affirming.
Okay, so it
that.
depends on the
Right.
verbiage of the
Correct.
resolution. All right.
And I have no preferences to either.
Either way,
Whichever
would be
way
okay
we-
for us?
Yeah.
Okay, thank you. Who would like to start the discussion?
Sure.
Go ahead, Jeff.
I think the staff got it right. I mean, whether it's the way the code should be written or not isn't up to us. It's the way it's written. And, you know, I spent a lot of time kind of looking at the definition of a front yard and a rear yard, but I think the last thing I read is more clear. Where lots have double frontage, the required front yard shall be provided on both streets. So that's a front yard off of Huntcrest. You know, going back to the line, the point of the main structure that's closest to the road. So under that definition and the other definitions of yards, that's clearly in a front yard. You know, again, whether I would have written it that way is of no consequence. That's the way it's written. I think that is very clear. I think the staff got that right. You know, whether it's appropriate for a variance is a separate question. If he wants to apply for variance, he can do that and notice the neighbors, and we can have a hearing on that another time if he wants to do that. It seems not just correct, but clearly correct to me. And so my view is that we should affirm the staff's interpretation of the code and reject the appeal.
Okay. Thanks, Jeff. Paul, do you have any thoughts on it?
I concur. I'd be in favor of affirming staff opinion.
Steve?
Yeah, I was wanting to hear something from the appellant regarding code issues. And I wrote down a couple items here. That the location of the fence, that it has to be there, that it needs to be there, which to me are not zoning issues at all. So lacking, I think, any appeal regarding our zoning code, and thanks to Mr. Nye for his detailed analysis there, going back especially at the end, that I would concur to deny the appeal and affirms staff's interpretation.
John, what are your thoughts on the matter?
I agree with staff.
Okay. I believe that staff acted properly in this matter. And is there any further discussion before we come up with a motion? Would someone like to present a motion?
Mr. Chair, with regard to case number 1-2023 BZA, I move that we affirm staff's interpretation of the code and reject the appeal.
Okay.
Second the motion.
Okay. Will you call the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. The board will be in contact with the board. Excuse me. Can I have a motion to come out?
So moved.
Second.
Second.
Will you call the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. The board will contact you when this is, the paperwork is complete on that, and then you can decide to take whatever further action you wish in this matter. Okay? Feel free to contact them at your earliest convenience. Okay. Now, will the staff read case 2-2023?
Case 2, 2023 BZA, applicant Ross Webster of Mio's Pizzeria, Happy Two Brewery, for Clough and 8 Mile 1 Center 1 LLC, property owner. Location is 8298 Clough Pike, number 6. As a note, the adjacent parcel to the west of this property, ending in 016, is zoned B residential and was approved a special use certificate through BZA for a parking lot. The zoning of this particular parcel is E retail. The request is a variance, and the applicant is proposing a detached accessory structure size 20 by 30 in the front yard area, with a front yard setback of 68 feet and a side yard setback of 1 foot to the neighboring parcel 016, which is that parking lot, and 130 feet to parcel 019, which is a single-family residence, where accessory structures are only permitted in the rear yard area. This accessory structure is an outdoor seating area with a roof and takes up 4 parking spaces. Permit history and BZA history: 2002, new commercial building. 2003, case 3, 2003 BZA was granted a special zoning certificate for 34 parking spaces for the commercial building in a residential zoning district owned by the same owner. 2005 commercial addition, New outdoor seating area for Mio's, size 14 by 21. 2016 change of use and interior renovation to create a microbrewery area inside of the existing restaurant dining space. The building was constructed in 2002, purchased by the current property owner in 2022. September 22nd, 2022, staff received a complaint of an accessory structure without a permit. Upon inspection on the 23rd, the complaint was confirmed. The applicant has built the accessory structure without applying for a zoning certificate. A zoning violation letter was sent on the 24th. No response was received from the property owner, so a second violation letter was sent on October 24th. On November 2nd, the applicant came into Anderson Center to speak with staff and submit plans for the accessory structure. Due to the location of the accessory structure in the front yard area, the applicant was notified that he can apply for the BZA and was issued a notice of refusal. He did not apply for the December BZA hearing, but did apply for January. This is a property map. This shows the main parcel of the building, and then outlined in blue is that second parcel, which is zoned B, residential, versus E, retail. This is an aerial view. You can see that there's some foliage or trees kind of separating this residence from the property. The topography is fairly flat, but slightly steeper on the west side. This is the applicant's submittal. Detached roof, 20 by 30, 68 feet to clough. 1 foot to that neighboring parcel line, which is the parking lot, and then 130 feet to the west. And these are photos of the accessory structure. From this view, you can kind of see back of house exterior, which is technically the rear yard area, but it would have crossed over parcel lines if it was placed there. This is a view on the 8 Mile side of the building. And then this is the addition that was granted a zoning certificate for an outdoor seating area. This is a view from the corner of 8 Mile and Clough. This is a view from the back of the lot, looking at the additional parking lot area of that second parcel. Variance findings. Staff is of the opinion that the variance is not substantial. The structure being at the front of the building makes it visible from both 8 Mile and Clough Pike. However, the roof structure does resemble the roof of the main building. There's also ample parking available, and the accessory structure adds an additional use, outdoor dining area for the building. The required parking for this location is 60 parking spaces at minimum, and there are 95 spots in total. The essential character of the neighborhood would not be altered, and adjoining properties would not suffer a substantial detriment as a result of the variance. The proposed structure is in a commercial area and would not have any effect on any adjacent residential areas. The variance would not adversely affect the delivery of governmental services. The property owner's predicament could be feasibly obviated through some method other than a variance. The applicant wishes for the structure to remain detached from the main building in the front yard area. However, if the applicant attached to the main building what would be considered an addition, a variance would not be required and would meet front yard setback requirements. Additionally, due to the lot being a corner lot, location of back of house exterior as stated earlier, the accessory structure could not be located on the west side of the building. Staff is of the opinion that the spirit and intent behind the zoning requirement would be observed by granting the variance. While the accessory structure is located in the front yard, and there being other methods than a variance to amend this, the essential character of the neighborhood would not be altered, and the outdoor seating area would add an additional use to the commercial building. These are the standards to be considered.
Okay. Are there any questions for the staff? Okay. Will the appellant or the appellant's representative come to the microphone, speak your name, identify yourself and your affiliation to the case?
Ross Webster. I'm at 762 Kingswood Court, and I'm the tenant of the building,
Okay, thank you.
Neo's.
Okay, you speak a little closer to the microphone,
Sure.
please?
Yeah.
Go ahead, present your
Oh,
reason.
so through COVID, it was deemed that pizza and beer were essential, and we, our other outside area in the front on 8 Mile, that it sort of turned into a makeshift drive-through through COVID, and so we kind of lost some of the seating out there, and we needed more outdoor seating because outdoor seating became important as well. So during that, so that was the most. It made most sense to put it there. It's right off the bar, and it doesn't take up too many parking spaces. There's still plenty of parking there. All the other tenants in the building are gone at night, so it just made sense to go there with it. So I think that's everything.
Okay. Anything else you'd like to add? You good?
Nope.
Okay. Any questions from the board? None. Thank you.
Yep. Thank you.
Is there anyone present who would like to speak in support of it? Is there anyone who would like to speak in objection to this? Anyone like to speak in objection? Hearing none, I'd entertain a motion to go in executive session.
So moved.
Second.
We read the roll, please.
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Would someone like to start the discussion? If nobody else, I'll step forward. I see no reason not to approve this. I mean, if they had stuck a bar between that and the corner of the building, it would be in conformance. The only thing, and this is an aside, not necessarily this case, and Steve, you probably have the same feeling, how do builders do these things without permits? You know, because I'm in the construction industry, you're related to the construction industry, but that's aside and not germane to this, okay? But I see no reason not to approve this.
Are you saying that if it were attached?
Yeah, that's the way I read that. If
It would
he
be-
ran a
Which
1-inch bar from that building to the other building,
Yeah.
it'd be considered a detached structure.
Yeah, okay, yeah, and that's what
Yeah.
that's what I thought, yeah.
Okay. All right, any other discussion? Is there a motion?
Mr. Chair, regarding case number 2-2023 BZA, I move that we grant the variance request for a detached accessory structure as enumerated in staff's report. And I just don't think that at this place and time that there are going to be any conditions because it is existing.
Is there a second?
Second the motion?
Will you read the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Feel free to have contact with the board. They should have that appeal ready in the next day or two. You can pick it up here at your convenience.
Motion to
I
leave
never motion to
executive.
come out. Go ahead, motion me out.
Motion to leave executive session.
Second, will you read the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye, and we are officially out of executive. Okay. Now will you read case 2-2023? 3-2023. That's why you're here, John. Correct me.
That's why I'm vice chair.
Case 3-2023 BZA, applicant Kevin and Laura Schmidt, property owners, location 1145 Pamela Road, Zone C residence. It's a variance request. The applicant is proposing an attached garage addition in an L shape, extending from their current garage, approximately size 15 by 20 and 10 by 35. Approximately 650 square feet in the front yard and side yard areas with a front yard setback of 15 feet where 30-foot front yard setback is required. This garage addition would change the setback to 5 feet to the side property line and 15 to the front property line. permitting history: 92, construction of a new single-family residence; 2000, a fence; 2001, a rear addition deck, rope bridge; 2007, decks and accessory structure. The building was constructed in May of 92 and purchased by the current property owner in 2000. This is a property map. It's a panhandle lot with access to Pamela over here. An aerial map. You can kind of see the deck and accessory structure in the back. And then this is a private lane that goes up the middle. Topography map. It's fairly flat. And this is an area map showing other Pamela residences. There's 4 groups of 3. And these panhandle lots predate the current zoning text amendments for panhandle lots. Here's a site plan provided by the applicant. Here's the top view. The front view of the existing and new garage. The side view. The back view. A rendering of the existing garage and then the addition. This is a view of the current home. This is looking at 1145 Pamela, and then their neighbor to the right. A view of the garage, and it would extend off to the left. Here you can kind of see where it was marked. The garage would extend this way and then into the side yard over here. Here you can see the neighbor off to the left. That's the neighbor's fence. Here's the front yard of 1145 Pamela, but it's also the backyard of the house in front of it, which I believe is 1143. Here's the rear of the lot. This is kind of an additional parking space area for both the neighbor on the right in this paved area. Over here is gravel, and technically cars can't park there. This is a view of the rear yard. Variance findings. Staff is of the opinion that the variance is substantial. The lot is a panhandle lot, however, it predates text amendments adopted for panhandle lots, which require panhandle lots to be double the size. So this particular lot has similar acreage to the lot in front of it. Additionally, the lots in this subdivision, Hannah subdivision, are small in size with very tight lots and built at the required front yard setbacks of 30 feet. Therefore, the garage addition would be visible from Pamela Road and very visible to all surrounding neighbors. The essential character of the neighborhood would be altered, and adjoining properties would suffer a substantial detriment as a result of the variance. While the current house does not sit 5 feet from the side property line, the side yard portion of the garage addition would bring the house to the 5-foot required side yard setback. While this portion would be in compliance, meeting the side yard setback requirement, the lot is already very tight, as previously mentioned. In addition, the portion of the addition extending into the front yard setback is substantial in size, as it would have a 15-foot front yard setback when 30 feet is required. Also, due to how the lots are situated in the Hannah subdivision, the lot in front of the panhandle lots have their backyards directly view the panhandle lots behind them. While the applicant wishes for the addition to keep the same look and feel of the houses in the subdivision, the size of the addition is substantial and very visible to all neighbors. The property owner's predicament could be feasibly obviated through some method other than a variance. While there is not room in the rear yard to build a detached garage due to a deck and accessory structure already located there, the garage could still be extended into the side yard, creating a deeper garage that would not require a variance. Also, the other homes in this subdivision are experiencing similar circumstances of having tight lots and homes built at the front yard setbacks, leaving no room for any additions without a variance. Staff is of the opinion that the spirit and intent behind the zoning requirement would not be observed by granting the variance, while a portion of the proposed garage addition extending into the side yard would not require a variance, and the facade of the addition will have a similar look and feel to the house and houses in the subdivision. The size of the garage addition extending 15 feet into the 30-foot required setback is substantial, The proposed addition would also be very visible to surrounding neighbors who are also experiencing similar circumstances of tight lots. These are the standards to be considered.
Any questions from staff?
Yes. The side required setback is 5 feet?
Yes.
So it would comply with that?
Yes.
And the front setback required is 30 feet?
Yes.
And it currently is 30 feet?
Yes.
So if they wanted to expand, they could expand in the side yard as of right, 10 more feet along sort of the entire existing house to the
Yes.
back. Could they also expand in sort of like where the existing front of the garage is? Could they expand out toward the driveway?
I believe so.
I think they could, right?
Yeah.
Okay. That's all. Thank you.
Any other questions for staff? Will the appellant or the appellant's representative come to the podium, speak your name, your affiliation, and present your case?
Hi, Kevin Schmidt. What else was I supposed to, my name and what?
The name, address, yeah.
1145 Pamela Road.
And you're the owner?
I am the owner,
Okay.
yes. So, yeah, these, we've lived here for 20-some years, and you called it a panhandle lot. I don't know how rare that is to have a set of houses back behind another set of houses. There's, an argument to be made, like, what really is our front yard? Like, is it the setback from Pamela? Or I kind of feel like our front yard is the setback from our private lane. You can make an argument there, but even if you have it firmly in your mind that the setback is from Pamela, I'd still like to request a variance, and the reason is because these houses, the builder just crammed these things in there. As Lauren pointed out, he just crammed them in there before the codes were. Nobody has, the lots are so small, nobody has, not that you couldn't, but none of the 12 houses do have a shed, so everyone's lawn and garden is in their garage. We've never been able to park a car in our garage. The lots on the end owned by the Bigelows are double wide lots. They could very much have an easier time building a shed. Parking is also difficult because when you get the two cars in there, on one side you're stepping out into the mud, the other side you've got inches before the front steps. So we only get, one car in there. Some of the other neighbors pack 2 cars in there. I can't do it. It's like sardines trying to get 2 cars in there. So we really have 2 parking spots. And even to get that 1 second parking spot, I had to add 3 feet of asphalt to even be able to get 2 cars. Because when we first came in there, you couldn't even get 2 cars there down on the end of the lane. So I added 3 feet of asphalt there just so we could get 2 cars in there. I can't park on the lane. It's too skinny. And everyone here can, everybody's got the lawn and garden and their tools and whatnot. And that situation is also aggravated. I'm a small business owner. I have a tour boat business called SS Tiki Tours. The boats are stored in Amelia. During the on-season, they're on the Ohio River. I own a lot more tools now because I do I'm a small business. I can't afford, I don't know if you know what marine mechanics cost, but they'll charge you an arm and a leg. So I've come to own a lot more tools now. I would love to, if I was a big, wealthy company, I would purchase commercial real estate and, have a big shop and whatever. I can't, I'm just a small little fish. I do have a lot more tools than I used to have. And I can still function in the garage, but it's like move 6 things out of the way to get to what you need to do. And it's just that combined with the storage and the parking. And it's just, I also believe it won't disrupt the green space. We have plenty of green space between the houses. If every house is bumped out 15 feet on their garage, I don't think it would affect the character of the neighborhood. We love this neighborhood. We love the houses, the look and feel of them, everything. And I think every one of these houses would benefit by adding a 3rd car garage because the builder just crammed us all in there like they should have all been double lots in the back, but they didn't. So, that's just, it is the way it is. I guess we've outgrown the house. If this is denied, we're going to move out of Anderson. But it is what it is. We're fine with it either way. Whatever it comes down to, we just thought we'd submit an appeal as an attempt to, see if we can. We also met with the neighbors and came up with a list of community concerns, and I kind of responded to those. I think
we
that got
have those,
distributed.
yes.
Okay. So other than that, I don't have much more to say.
Thank you. Are any questions from staff? Okay, is there anyone present who would like to speak in support? Anyone in support? Is there anyone who would like to speak in opposition? Okay, we'll do one at a time. Well, you in the front, or you're going? Yeah, okay, come to the podium. Speak your name, your affiliation,
Yep,
your
my name
address.
is Justin Benomny, property owner at 1135 Pamela Road, right next to Kevin and Lori there.
So you're on the right picture there.
I'm on the left in that picture
yeah,
right there.
Okay.
So right next to where the
okay.
would
Thank
be
you.
coming out onto the side yard there. And I just feel like, as has clearly been demonstrated, these are extremely tight lots as it is. It's a substantial structure that he's looking to add on. Very obtrusive. From that bay window there, I would completely lose any. So from my view right there, I can see Kay and Dave's house, which is right in front of Kevin and Lori. I can see over to Brian and Beth's house, and then out to Pamela Road. I would completely lose any visibility to about a third of Dave and Kay's house would be all I could see. Otherwise, it'd be a very commercial, industrial feel, to have a large structure like that. And I understand the side yard can come, within the 5-foot variance, so that's, obviously not the issue, but it would be the additional 15 feet going out that would completely block my view in. I just feel like it would completely, change the aesthetics of the neighborhood, of the green space. With the lots being the size they are, it's not feasible to go from a 400 square foot garage to over 1,000 square foot. And would just ask that the staff hold to the spirit and intent of the zoning law, and agree with the variance as is.
Thank you. Any questions from the board? Thank you. Just going forward, just remember, I know there's others who want to speak in opposition, but we'd like to hear new information, so if possible. So who else would like to speak in opposition? Okay, please come, identify yourself, your affiliation, and present your...
I'm Evelyn Bram, and I live on the other side at 1133 Pamela. And what bothers me is, first of all, he keeps saying, how it was thrown together. They're so small. It's like, why did you buy it? Move somewhere else. But I think would change.
I'm sorry, what was your name?
Evelyn Bram.
Thank you.
Brehm.
Do you live where the red car is?
No, I live to the east.
Can you put the plot map up so we can sort of identify that better? Okay. So which house are you? What's the address?
1133.
1133? Okay. 43. Okay.
So you have a
33.
panhandle lot too.
Okay, yes. Okay, thank you. Now I get a perspective. That's what I wanted. Okay.
So,
thank you.
I think if somebody wanted to sell the house or something, I just think that would destroy the feel of it. Exactly like Justin had said, it's going to make it look more commercial and crammed together. I don't understand, these people, if he lived there 20 plus years, they put their lawn stuff up, up till today. We all go through the same thing, so I have an issue with it, yeah.
Thank you. Else, don't go away yet. Any questions from the board? Thank you.
Done.
Okay. Who else would like to speak in opposition? Please come to the podium, identify yourself and your affiliation.
You guys probably don't want to hear me. My name is Kay Farrell. I am at 1143 Pamela Road, right behind Kevin's house.
Okay.
Vision it. I have a deck, very private, very nice. Normally I look out at trees and everything's wonderful. Now I'm going to have, if it's approved, which there's other options, believe me, I'm going to look at this big square. I don't care if it's got windows or what, it's going to be in my face. From here to here, there it is, from my deck. And I'm very much against it. I feel that Kevin and Laura have room. We have a 2-car garage. They use theirs for storage. Laura only wants 1 car in the driveway, which is hers. We have 2 to 4 sometimes. They also added an extra pad for Kevin's car or the extra car. They have more than what we have. Their son parks on the road where he can park in the back as well. Like, we all do it. So to me, there is no reason for this to go through. I won't keep talking because I'm probably the most upset because it's right there and takes away our greenery. That's the reason we all bought the place, was because of the lot area. Okay?
Just take your time. We're not in any
Oh, no.
rush here, okay?
You don't want to get me going.
Okay.
But I just can't justify it. I would move to a bigger place, or here's the options, and Kevin should know this: rent a storage. Rent a storage and put all your boat stuff, what you need to do in storage. The parking's really not a problem. The garage isn't necessary whatsoever. And the storage down the house, I mean, what's that for? We all have full basements. Our houses are alike. And we all pretty much care about each other and what we all feel and think about our property. And it is an investment for me and my husband. It was an investment, and I know, and we're getting older, we'll probably sell in a year or two, whatever we decide to do. Our property is going to hurt from this, because I would not look at our house, which is very nicely done, go out on the deck and go, whoa, what's that? There's no way. It's going to hurt our property. And that's the way I feel, and I know I'm strong about it, but I think all of you, if you stood on my deck and saw what you're looking at, you would be in shock. And I'm at 1143. There he is where the screen is.
Thank you. Any questions from the board?
And your deck is in the
You can
back?
pull it up a picture if you like. Back up. Let's see. My deck is over there. Do you see his little sticks? Go over another 3 or 4 feet, and then that's our property a little in front of those trees there. Plus, he's going to be taking out a beautiful big tree to do this, plus going to put in a driveway. All of that is just not going to fit in they're very cottagey, warm homes, and you don't make keep going. The greenery is very important to all of us, more than anything in the world. So we'll see.
Any further questions?
So those 2 trees kind of in the middle of this photo, those are on your property?
That's my property. Come
And-
this way now, you're coming to his property. Keep coming. About right there. Well, go over a little bit more.
I got a sense of it.
Yeah. That's where it is. It's going to be right there, and then there'll be bushes in front of that, of course, if you're still coming in. But we sit on our deck all the time and enjoy it. Grandchildren go out in the yard. It's going to be different. It's going to be different. And I can guarantee you most of the neighbors will sell eventually because of this, because they're not going to want people to start, well, I'd love a pool in my backyard. You know, maybe I should come and try to get a pool approval. So it's going to bring up questions of, well, what do you want to do? What can we do? So I say move, get the storage you want, or say, okay, it doesn't work, and use other options.
Any further questions?
And I apologize for my
No,
temperament.
don't. You're good. Just take your time.
Are you all done?
Yes, thank you.
Okay, thank you.
Anyone else would like to speak in opposition, please come to the podium. State your name and affiliation and address.
I don't normally have to raise
Could you go
microphones.
back to the
I'm Heather Stonecipher. I am the red car person, so we're at 1147. So we have one thing we would just want to echo in agreement with. His name is Justin, who said the size of this is substantial. So if you think about the footprint of the garage, it's actually it's 30 feet bigger than the footprint of the house. And the increase in size is, it's 1.6 times the current garage space. So, and I think there's been a lot of points about the parking and garage space that's already available, and we're all kind of sitting with the same situation. Houses are very similar, so no lie there. And I do have pictures of parking, if it's helpful for you, of how people park their cars. I see that it was kind of like a light day. It's your option if you wanted to see those. But but there are definitely ways that people make
If you-
parking
if
work.
you'd like to present them to the
Sure.
staff, then we'll take a look at them. Thank you.
For us too, precedent was one of the
Could
main
you-
concerns.
She didn't get your name.
Sure.
Could you
I'm
repeat
Heather
your-
Stonecipher. I know, I was gonna just walk up and spell it. Stone, I almost didn't change my name, but anyway, that aside, Stonecipher is S-T-O-N-C, wait, honey, did I get it right? It's Stone, C-I-P-H-E-R. I don't know where I was. Okay.
Anything else to add?
I do. So precedent, like I think Kay kind of mentioned this, but allowing this variance to opens up the addition for others to keep doing it. And then I think that it disrupts the spirit and of the variance of why it was put in place to begin with. We don't need or want, people don't want houses sitting right on top of each other. I think that if you continue to do that, there's a potential that that would be a neighborhood no one would want to live in. So I think it would limit future attractability. For us, disruption of use is a concern. We are Red Car, so we're right next door. So I would assume that the construction would involve the easement and the use, potentially blocking our use of our own driveway and access to our house. I think this was mentioned. So I'm going to agree with other solutions exist, and I already shared with you that there's adequate parking for 3 cars. So I will skip on. That we think that would remedy their issue, and that wouldn't adversely affect any of us, right? If they use the space that they had in a different way. I think that's all I have.
Thank you. Any
for me?
questions from the board? Thank you again.
Thank you.
Was there anyone else who'd like to speak in opposition? Please come to the podium. Identify yourself and your affiliation.
I'm David Farrell, the husband of the first one that talked, or the second one, I'm not sure. Basically, I kind of agree with the staff review. They had a set of 7 criteria to look at. I went through them and what would be my comments in relationship to the staff. But the variance is the one that, if you look at the variance, takes up 50% of the setback requirement. And the footprint of the proposed structure to be built is 1.6 times the current footprint. I just don't believe that it's going to not that it's not going to affect the aesthetics of the setting that we have. Some of the other points, criteria that was set was, is there other options? Well, there are always other options, and some that's been taken, has been identified, so I won't go into that any further. So my bottom line is I think the staff review got it right, and I don't see any reason to overview.
Any questions from staff? Thank you very much. Anyone else who'd like to speak in opposition, please come to the podium. No, she's coming first. I'll recognize you in a minute. Identify yourself and present your information.
I am Lisa Sutherland. I live at 1155 Pamela Road. Caddy corner to the Schmitz. Nope,
Okay.
next one over. Come down. There you go.
You're at 1149.
1155.
Okay, 1155, okay.
I guess the benefit of kind of going last is I don't have much here to say other than I support everyone's opinions. I think that the whole feel of our community would change. It's one of the reasons that I bought the house. Walk in, there's feelings, you think, oh my God, I'm living in a park. You know, this is really cool. We're all common houses, but very different on the inside. I think it's going to change the feel of our community. That's it.
Okay, any questions from the board? Thank you.
Yep.
Is there anyone else who'd like to speak in opposition? Please come to the podium and identify yourself and present your information.
My name is John Plavinsonk. I reside at 1131 Pamela Road, which is the bottom house on your map there. My previous occupation, I was a County Regional Planning Commission Director for Sandusky County. I've just got 2 comments to make. Number 1, I concur with the assessment made by the staff, particularly on point number 3 of the criteria to be utilized for the board. The second comment I have is that if you approve this variance, there's nothing to stop other individuals in that complex from making the same suggestions and winding up with 2 or 3 developments like this. Thank you. Any questions?
Any questions from staff? No? Thank you. Is there anyone else who'd like to speak in opposition? Mr. and Mrs. Schmidt, do you have any additional information or rebuttal you'd like to address?
No, this was just an
Okay.
idea that we had. We threw it out.
Okay, no, it's fine. I just was asking if you had any additional information, it would be the time. Okay, thank you. Is there a motion to go in executive session?
So moved.
Second.
Do we call the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Would someone like to lead the discussion?
Yeah, I am in support of staff's opinion that this is a substantial request. And I'm always looking towards that item number 3, which we just talked about, that the essential character of the neighborhood is going to be substantially altered. Not only because of the geometry, the location, the design of it, all of these houses have substantially, like a 12 and 12 steep pitches, and this shallow pitched roof, I think, would be very detrimental to the character of the neighborhood. Going down to number 6, the property owner's predicament can be feasibly obviated through some other method. I mean, what I think is challenging for me here is the business needs in a residential location, and I understand that the business may be run out of the home, but the fact that tools, repairs, or whatnot would seem to me that the location of that would be better suited elsewhere other than within a residential area, or being the substantiating reason behind such a significant increase in area and the encroachment into the outdoor area. And that's why we have these setbacks, is to maintain that outdoor area that has been talked about so much. So I am in the position to deny this variance request for those reasons.
Paul, your thoughts?
I'm in agreement with Mr. Haber.
Okay. John?
Same.
Jeff?
Yeah, I appreciate what you guys are trying to do here, and I appreciate your predicament, but it is, I think it is clear that it would affect the character of the neighborhood. There are 10 houses on the screen here. We heard from 6 neighbors that said, you know, it's just too much for us. And it is substantial, 15 out of 30 feet. I think I would deny the variance.
I would agree with staff's opinion. Is there a motion?
Mr. Chair, regarding case number 3-2023 BZA, I move that we deny a variance request to allow an addition and attached garage. I'm going to include staff's report that this variance is substantial, that the essential character of the neighborhood would be substantially changed. The property owner's predicament can be feasibly obviated through some method other than a variance. And if there's anything else, I'll certainly welcome friendly amendments.
Is there a second?
I'll second.
Will you please read the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Is there a motion to come out of executive session?
So moved.
Second? Second? Second, Jeff? Okay, we call the roll.
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Getting stuff, the documentation will be available through the township the next 2 to 3 days, okay? Thank you. Will you read case 4-2023, please? Okay.
You think we're good? Okay. Case 4-2023 BZA, applicant Architects 2 Limited on behalf of EBC Estates LLC property owner. Location 8050 Ayers Road, zoned AA residence. It's 2 variance requests. The applicant has proposed 1, to construct an in-ground pool size 20 by 40 in the side yard area of their property. We're only permitted in the rear yard. Second, variance request, the applicant is also proposing 4 motor court masonry accent walls to be 4 feet high and located in the front and side yard, where walls or fences must not exceed 4 feet in height and must be at least 75% open per article. The yard designations are determined by the minimum horizontal distance between the street line and the main building line, not the orientation of the single-family home on the lot. This house will be located on a private drive with 2 other houses and 1 vacant lot. History, the property owner purchased the lot in 2021. A permit was issued for a single-family residence on this property December 21st of 2022, so recently. As a note, the parcel has been officially assigned the address of 8050 Ayers Road by Hamilton County after the plans were submitted. Here's a property map. As you can see, it is a large lot, roughly over 60 acres. It's also irregularly shaped. Here's an aerial view. You can kind of see the 2 other houses on that private drive. Topography map. The flattest area is roughly around here where the house will be built, and it gets a lot steeper as you kind of go away from it. Here's the plot plan, and I'm just going to point out the front and side and rear yards while we're at it, because this is where Ayers Road ends. This is considered the front yard area. The house faces the side yard area, and that's where the 4 masonry accent walls are. This is also the side yard area that faces the lake, and that's where the pool will be. And then this is what's considered the rear yard area. This is the pool terrace plan. Here's a rendering of the front entry and the 4 accent walls. Here is a rendering of the rear. and the pool. This is the road yet to be paved to the property. This is kind of that flat plateau area. The house has not been built yet. This is in the side yard overlooking the lake. You can kind of see there's a hill, and then the house is up on the hill on the other side. This is kind of to the left of the lake. You can see more houses. And this is kind of a view from the flat area looking at that second residence on the private drive. And this is the end of errors. Variance findings. Staff is of the opinion that the variance would not be substantial. The location of the pool would be approximately 800 feet from the property line to the west and approximately over 550 feet from the property line to the north. The required setback for a pool in the rear yard is 3 feet from the edge of pavement around the pool. The applicant has ample space on the property to provide an adequate buffer. Similarly, for the motorcade walls, they are proposed to be located approximately 600 feet from the south property line and approximately 800 feet from the east property line. The lot is over 60 acres. The essential character of the neighborhood would not be altered, and adjoining properties would not suffer a substantial detriment as a result of the variance. The applicant has provided graphics illustrating how the proposed pool area and the motorcade walls will fit with the character of the house as well as surrounding properties on Ayers Road. The variance would not adversely affect the delivery of governmental services. The owner's predicament cannot be feasibly obviated through some method other than a variance. While the applicant was aware of the issue that the orientation of the proposed single-family residence would provide when determining the yard areas, the applicant has stated that the topography lends itself to being constructed in this manner. The house is permitted to be constructed on the plateau of the property. Staff is of the opinion that the spirit and intent behind the zoning requirement would be observed by granting the variance based on the substantial buffer and distance from the proposed pool and motorcade walls to the closest property lines, as well as the large size of the lot. Standards to be considered.
Questions for staff?
None.
Is this the property that we had a variance with?
No.
Your
I got confused when I went out there.
With
too.
a sign that was supposed to?
Yeah.
This is it, right?
Yeah.
Well, it's in the same,
matters,
oh,
but-
you signage, I think, we had a
That's when the
variance.
property was for sale.
Was marked.
Yes,
Okay.
that's correct.
Yeah,
I was driving over there and thought, I've been here before.
yeah.
Okay.
So yes, there was a
Well, I thought
variance
you-
request for the sign,
Yeah.
but then the property sold, the
Yeah.
sign's been
Yeah.
removed. This is the same property. That's
Yeah, this is like
Okay.
the second variance we've had in that area, yeah.
On the same lot, okay.
Okay.
All right.
Any further questions for staff? Will the applicant or the applicant's representative come to the podium, identify yourself, and present your case?
My name is Steve Ginter, Architects 2, architect for the house. I'm representing the owner. Case-wise, of course, we agree with the staff. That was our argument for everything. Spent a lot of time with the owner on the lot prior to the design of the house, walking it, and of course, it has the lake on there, which is probably one of the best views across there. So that's really the orientation of the house, plus the way the topography worked. So we really just sort of studied the lot. We walked down around the lake. To the left of the house, which is really kind of side/front, there's a ravine coming through, which I believe he's intending on planting that with a small orchard. But just with the character, everything else, taking advantage of the sunset, the lake, the orientation just seemed to work the best for this. I'm really here more to answer your questions beyond that.
Any questions from staff, from the board? Thank you. Is there anyone else here who would like to speak in support? Is there anyone who'd like to speak in opposition? Is there a motion to go into executive session?
So moved.
Second?
Second.
Will you read the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Would someone like to lead the discussion?
Based
John?
on the size of the plot, the location, I don't think it's going to have any I mean, we've been in that neighborhood a couple times now.
Yeah.
So, I mean, the houses are kind of spread out. They're large houses, and I think the character, the features fit into that neighborhood.
John, anything to add?
Nope, I'm okay with it.
Steve?
Well, the only thing that I would have concern is the size of the property, I think is one reason why I mean, I think staff's report said it's 800 feet over here and 600 feet over there, is should the property owner wish to subdivide? And I don't even know if that even enters into a discussion here, or if it's a condition or what, but the size of this 60 acres seems that, yeah, we could carve this thing up and, you know, maybe put a couple of, you know, at least a couple other houses of this nature on there, which I think would be, what am I trying to say? So, you know, substantial for the property owner. And I just wondered if that should come into our
calculus.
That.
Can we see the topography map, please?
I'll address that. I don't think it should at all. If they decide they want to sell that lot and put somebody else 3 feet from their side, that's a different zoning and it'd be addressed at that time. I don't think we need to put or should put any conditions on them reselling any part of this lot.
Then let me restate what I think I just heard you say, and that is we are going to consider this case, and if and when the property owner should decide to do something else with that, then we'll consider it then.
I see no reason as a board that we should put any restrictions on this or a similar property. If I have a 5-acre plot, which I do have, should the board put restrictions on me that at some point in the future I can't sell 2 acres of that?
Depending upon the location of your house and a future location of a property line, yes.
No, I completely disagree with it.
I would disagree as well. I think the request before you tonight is a pool in the side
No,
yard
I'm
area.
sorry. I just,
Well, if I could finish my thought.
Yeah, go ahead.
Because I'll lose it.
okay. Go, Paul.
We can't speculate what's going to happen to this property in the future. They have 60 acres. They have every right to subdivide in the future, but that shouldn't bear any bear on your decision tonight.
On this
What
case.
may happen in the future.
Right.
They may keep it 60 acres forever. They may subdivide it next year, but that shouldn't impact your decision on what's before you tonight.
Right.
So what's before you tonight is a 60-acre lot. Due to the orientation of the home, the pool is considered to be in the side yard. The
Right.
motorcade walls are considered to be in the side, possibly the front. So that's what's before you tonight, and I think we need to stick specifically to the request tonight and not speculate what could happen in the future.
And just to add to that, I mean, if that does happen in the future, there is a process that they'll have to go
Correct,
through.
yes.
So it's not like it's going to be automatic and.
Well, the variance runs with the land, but there could be, if they redevelop the land, subdivide the land, it could actually change the orientation of the home. The road could come out in front of the home, which
Right.
actually would make the pool in the correct area. But again, we can't speculate what's going to happen, so we just need to make a decision based on what's before you tonight.
Jeff, you look like you were going to add something earlier.
I had two thoughts. One that I probably should have asked of staff earlier. Isn't there a rule where, so we determined the front based on where Ayers is, but isn't there a rule where if a private drive serves a certain number of houses, then it becomes a street? And what is that number? Because there's 3 on there now, or this would be 3.
I can answer this, Lauren, if you want me to. So there is a rule that off of 3, if a private drive serves more than 3 homes, we treat the private drive as a public street. Our interpretation of this, though, is that private drive, and I don't have a cursor, but it stops where, right there, Lauren.
Where
Right
that
there,
happened.
that it stops there, that this is, because
see.
there are no more lots on that.
So
Ultimately, it could change if it is subdivided, but a new lot would have to have frontage on a public street, and so again, that changes everything as well.
I'm with you.
Yeah.
Okay, appreciate that
But
clarification.
those houses that are already constructed, there are 2 houses that are constructed, they have a front yard setback to the private drive. They are required to have a front yard setback to the private drive.
Okay, I understand and appreciate that clarification, thank you. I had the same thought as Steve did. I wrote down in a half scribble here, condition regarding subdivision. But, you know, and my argument for why we should consider it is that maybe that's something we need to consider in the spirit and intent of the zoning requirement. But even with that, I think all the other factors favor granting the variance. So, you know, let's not let the tail wag the dog, and I would grant the variance.
So, any further discussion? Yeah, I support this and without any conditions that we discussed so far. Is there a motion?
Mr. Chair, regarding case number 4-2023 BZA, excuse me, I move that we grant the two variance requests as enumerated in staff's report and included, and I'm looking for drawings. Two conditions. Where are they? Drawings.
12/15/22.
In substantial conformance with the drawings dated, you say 12/15?
22.
2022,
And then there's one, there are two sets of drawings, and the other set is 11/10/22.
Well, we would enumerate both of those dates. And then construction started within 1 year and completed within 2.
Just real quick with that, on the size of this home, I would request you give them 3 years.
Started 1, completed within 3?
Right, because I think the pool will be started later after the house anyway. Potentially, I don't know that for certain.
That's fine.
Could we come out,
could at
and
least
could we
give
come
them-
out and ask that if it's essential? Let's come out of executive session. If you, is it essential to you?
No,
to
let's
change?
just make it 3.
Okay, that's fine.
Yeah.
Okay.
Just make it 3.
I'll second the motion.
We call the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Contact staff. They'll have the documents you need. There's a set of plans if you need an extra set, because I won't be taking them home with me. Okay. Let's have a motion to, we did have a motion to come out. Did I do it?
So moved.
So moved.
Moved and passed, yes, by accord. We have a couple of business items before we get into the other. One is to pick a date for our training session, and the next is to vote on officers for next year. Do you have a projected date for a training session this year?
I did check with Gary, and he is fairly available, so he just asked that you provide a couple of dates that might work for you all.
I'm traveling a lot this month, so I would prefer a Monday or a Friday.
Not a Friday.
Okay, oh, come on. We can all go out and have beer afterwards. We can sit at tables next to each other and pretend we're not together.
Yeah, Mondays are good.
Okay.
I think I might have a haircut, but.
And so far, Chris and Lauren, I think we have a
You-
potential
you-
1 to 2 cases for February, is that right?
The 16th is Martin Luther King Day.
If not 3,
Yeah,
okay,
I
so,
can't that one. I can do the 23rd.
The 23rd will work for me. What, will the 23rd work for everybody? Will work for you? Okay.
I think so. Yeah.
So let's do the 23rd of January, is it, and you'll send out an email to us for that. Okay. Next item of business is elective officers for next year. Is there anyone who would like to campaign for a particular office or request a particular office, or do we want to do the annual one-year rotation?
Round robin, yep. That goes next.
We've done a one-year rotation in the past, is my understanding.
You're next,
Okay.
Steve.
I'm next.
Who's next?
Steve.
Oh, well, then we may want to talk about this.
I think it needs to at least go to 7 votes for
Okay.
crying out loud.
Yeah, we can carry this on for 2
9 or 10 now.
days. I object. Is there, I'll nominate Steve for chairman. Is there a nomination for secretary? And if you don't speak up, I'm going to nominate you.
Yeah, I don't remember how long it's been since I did it. Is it my turn?
Yes, you've just been nominated. I'm going to nominate Jeff for secretary.
I was secretary last year.
Yes, so,
Yeah.
there's a motion. Is there a vote?
What about vice chair?
Do we need a
Do we
vice
need a
chair?
vice chair?
We haven't had a vice chair, have we?
I'm a vice chair.
Okay. And then I'm going to nominate Paul, because I haven't seen you in office since I've been here for the 2.5 years, for vice chair. Is that, and that modified my
You
motion?
want Jeff to be, I mean, the vice chair will fill in for the chair when the chair is absent.
Yeah, okay, all right. Will you call the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. Now, tell my wife I'm still chairman, so if I come home 3 hours afterwards. Is there a motion to dismiss?
No, we got to journalize.
Oh, yeah, we got to do the voting,
So
yes, we got to do the.
and
yes, go ahead.
speaking of
Have
journalization,
those ready. Okay, so
One
they
and
were
three.
rejections? Okay, all right, that's fine.
How about 2 and 4?
Okay, let's go. Gary, just a point of clarification. I know we don't vote on a rejection. Is cases like this, I understand the one was controversial, but, you know, is that just to give you guys time to internally review?
it gives time for Gary to review. So if there is a higher chance that it would be appealed, we would prefer to have Gary review it in more detail.
Okay,
Just wait
thank
the
you.
extra month.
All
The
right.
impression is that it will go.
Are we ready? See, I've given you extra time.
Yeah.
That means more cookies next month if you're not ready.
Can't read from back there. No one ever sits in the front. I don't think they like you guys.
That's true.
Now that he's chairman, does Steve lose his designation as motion maker?
No, he can still do it.
Okay.
Just do it all.
All right.
It's your job now, Paul.
I figured I'd hold on. to
There
the
we go.
paperwork from number one, because we'll probably see it again. Personally, I felt like he had to take that fence down. Because he's going to take it down. Because you don't think he will?
Oh, no, he won't go to that, he won't go to that height.
He won't play court.
But he'll go there, he'll apply for a variance. That's my guess.
Yeah. And I'm gonna turn it down because
His big concern with the creek is he could live with a 4-foot fence, mostly open, and people can't cross it. Even a big fence like that, people still toss things over.
Plus, he was.
So you're still working for the Bearcats now? Nichols going?
Yeah, I've been doing it. Next year will be my 50th year as a volunteer.
Oh, really?
Yeah.
Oh, okay.
I don't care who's coach. Okay. All right. Which way are we scrolling, Jeff, up or down?
Up.
Okay. You can scroll up.
I just realized I've been dating things 2022 all day.
Oh, no. Hopefully it wasn't legal stuff.
Continue. I like 5. Okay. Okay. I think I'm good. Yep, go ahead.
Do you need a carriage return after 3? Or after 2? Oh, and then it's gonna mess you up. That's what,
I know what it is, but it's just.
That's typing class back in 1970.
There are no, did we do conditions on that? No, because it's an existing structure. There are no conditions. I'm good. Is there a motion?
Mr. Chair, regarding case 2-2023, I move that we approve and journal our decision.
Second.
Can we call the roll?
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye. I didn't read it that fast. You can scroll up again? Yeah.
Do you want to answer those two questions real quick from Word?
Okay, you can
Never, ever.
scroll.
800 feet from the property line. Must be nice.
I'm good. I'm good. Conditions are 1 and 3.
And substantial conformance with the plans dated whatever they were dated.
Yeah, and the plans, and then 1 year and 3 years. There are two, you got the due dates? Yeah. Okay.
Would this be the biggest parcel in Anderson? Pretty big. With a house on it?
Well, Ayers has a bunch of big houses on it.
Yeah.
60 acres.
There's one that has an AstroTurf backyard with a football striped out on it, football line striped
60
out.
acres is.
It's pretty big,
Yeah.
Where's that?
As you go back, as you come out of that property, you look down to the right, and there's a guy who's got a full basketball court with a chain link fence around it, and a AstroTurf backyard with striped off as a football.
And
You
there's
could do
a,
that on 5 acres. 12 times that.
there's also a
You
house.
could go hunting on this land.
There's a house at the end of Ayers there, too.
Okay, you can scroll up.
That guy must really love football.
The conditions,
Yep.
yes.
Yes.
And my last formal, scroll down just once. I just want to say that one more time to aggravate Jeff. Okay.
No, that's the
I
correct
missed,
answer.
There's also
Lauren,
a
did
guy
you
down
put,
at the end of Ayers
the
who has
BZA
a
approved this based off of the following conditions? It
There's
just
a
said,
fountain in the front yard.
Yeah, go back to the conditions again.
There's a
Was there
shooting
a,
range
It was 1 year, 3 years.
under one of
but,
his
then
garages.
but they were missing
Really?
some,
right,
yeah, after Board of Zoning Appeals, subject to the following conditions, 1 and 2, yeah.
right.
Good catch.
Is there, see, if I hadn't said scroll down, we wouldn't have found that.
Mr. Chair, regarding case.
Wait.
What?
Ch-
Colon. Ready?
Yes.
Mr. Chair, regarding case 4-2023, I move that we approve and journal our decision.
Second motion?
Call the roll.
Mr. Nye.
Aye.
Mr. Sion.
Aye.
Mr. Haber.
Aye.
Mr. Halpin.
Aye.
Mr. Shekels.
Aye.
Motion to adjourn?
Motion to adjourn, second. We call the roll?
Mr. Nye. Mr. Sion.
Aye.
Mr. Haber. Mr. Halpin. Mr. Shekels.
Aye. Garbage.